this afternoon to welcome our speaker, Deborah Carlson from the West Coast Environmental Law in Vancouver. And Deborah is a lawyer, right? And West Coast Environmental Law is a not-for-profit organization that works collectively at the local level on law and policy to address complex environmental issues. And who can imagine a more complex environmental issue than climate change? She's worked both in civil, she has both a civil and a common law degrees from McGill University. And she has 2 decades of experience working both in practicing litigation in private practice, as well as more recently working for environmental organizations. So please join me in welcoming Deborah this afternoon. And she's going to talk to us about climate change, legal risk, and opportunities for professionals. So Deborah, over to you. And I want to also let you know that this is being webcast, and so there are a number of people online watching this, and they'll also be involved, can also, I think, ask questions at the end as well, but they'll also be hearing your questions at the end. So we're going to ask people, when they ask a question, to speak into the microphone so everyone can hear. So with that, I'll turn it over to Deborah.
Thank you, Sybil. I'd like to start by acknowledging being here on the territory of the Lekwungen-speaking peoples at the University of Victoria. And also I'd like to acknowledge the territories of the Sanghees, Esquimalt, and Saanich peoples who have historical and continuing relationships with this territory, I understand. Thank you, Sybil, and thank you, Trevor, and thank you, Pix, for the invitation to share some information about climate change and the types of legal risks that professionals face with regards to climate change. But I will try to be not all doom and gloom, and I'm going to end the presentation with some thoughts about maybe where we can go that is hopeful. But there's definitely going to be some risk and some tough things in the middle. So I hope you're all ready for that this afternoon. So as Sybil mentioned, I'm a staff lawyer at West Coast Environmental Law. We're a not-for-profit environmental organization. As she mentioned, we're based in Vancouver on the shared territories of the Squamish, Musqueam, Tsleil-Waututh nations. But we do work around the province, and we also work in Ottawa on issues, federal issues that have an impact on us here in BC. We work to develop legal solutions that protect and sustain the environment. We work on collaborative legal strategies that bridge Indigenous and Canadian law. And we aim to support communities building a just and more sustainable future for everyone. So here's a bit of a roadmap about where we're going to go today. So first, some context. Why are we even talking about risk associated with climate change? And what is really the scale of the risk that we're facing? Second, what does this mean for professionals? And then finally, where is the good news, and how do we move forward in a good way, knowing what we know? So did everyone see the letter? I'm assuming I'm at a university, but this will be common knowledge. But did everyone see the letter from the 15,000 scientists? I see a show of hands. OK, most of you did. It wasn't really featured that prominently. I didn't find in news coverage, but 15,000 scientists, more than 15,000 scientists, including about 500 from Canada, issued a letter about a week ago warning us about the way we're treating our only home, planet Earth. This communique followed on an earlier warning that they had issued 25 years ago, back in 1992. And the bad news with this letter is that the scientists are letting us know that we haven't actually made much progress. They identified one thing that we're doing better, and that's protecting the ozone layer around the Earth. But everything else, it was a failing grade, essentially. And one of the key failures that we're in the middle of right now is that we're not reducing our greenhouse gas emissions. So the letter termed these various failures, including climate change impacts, as foreseen environmental challenges. And I want you to remember that because it's important in a legal context. So that was foreseen environmental challenges. So they're saying, we warned you about this 25 years ago. This is nothing new. There are 15,000 of us plus around the world who want to send this message to you, and we're not getting through. but we know what we're talking about. So this letter, it wasn't a scientific journal, but obviously there was a intention to communicate it to a broader audience. So we have some other signs for sure that all is not right in the world. We do expect that in our human communities that we face some disruption from nature. We call them natural hazards, and we're accustomed to this. Sometimes maybe we feel this more in Canada than some other places. But we do expect some level of disruption. And local governments plan for this. In fact, the Local Government Act in BC mandates that local governments do some planning and consideration of natural hazards. So that part isn't anything new. And we used to call the really big events acts of God or force majeure events. And I expect that you've heard these terms. We've used them in a legal context, but I imagine you've also heard this. And it was the idea that these things were extraordinary and we couldn't possibly predict them. But now what we see is that what once was rare is becoming much more commonplace. So this is a bar graph from the big reinsurer Munich Re, and it shows insured and non-insured losses in Canada from these different hazards over the period 1980 to 2016, so last year. So definitely over time there are spikes. So it's not exactly like there's a linear progression that's entirely obvious outwards, but if you look at it for a moment, you see that the spikes are getting higher and the spikes are getting more frequent. So the damage from these events is going up. So this is a trend for sure that we're seeing. So we do know that the climate is changing. We're seeing it, and we're already paying for it. More specifically, the wildfires in BC this summer. The province of BC estimates that just the firefighting efforts cost about $500 million, $500 million, that is. And the property losses are estimated at around $130 million. Interestingly, I was looking on the BC provincial website, and that's quite similar to the numbers from the fires in and around Kelowna and the Okanagan back in 2003. So, these are numbers that are becoming more and more common, and really that's actually quite small compared to the numbers that we saw with the Fort McMurray fires a couple years ago. So, these numbers are emerging across Canada and with growing frequency. The University of Waterloo estimates that paying for floods in Canada now costs about $600 million a year on average. And then some years ago, I don't know if anyone even remembers the National Roundtable on the Environment and the Economy, which used to produce a lot of very useful and interesting information. They prepared a report looking at the future costs associated with climate change impacts. And they estimated about $5 billion a year by 2020. And then by 2050, somewhere between $21 and $43 billion a year, depending on which scenario we land with. So by scenario, I mean how successful we are at reducing our greenhouse gas emissions. So really significant costs swirling around out there. Lots of damages. These are not exactly parallel data. So these are the costs of climate change impacts. So they could be sort of more low-level impacts as well, not necessarily full-scale disaster. But these are no. It's the cost of responding to the impacts. So we have this out there then. So if you're a lawyer, and especially if you're a litigation lawyer, this gets you thinking. What can we do about this? This is a lot of damage. This is a lot of loss. Who's really responsible for that? Who's going to pay for this? So there have been some ideas about who might pay for this. I mean, the obvious one, I suppose, is governments and taxpayers, because we usually expect the government to pay for these natural disasters. When we have flood, we have disaster financial assistance. When we have wildfires, we have the government stepping in, and we just add it up onto our tax bill, essentially. And the government is left at various levels of making choices between, the things that they have to cut in other places in order to make these payments. Often, some of the costs will fall to property owners as well. As you saw in that first graph, the bar graph, there were insured losses and uninsured losses. So the uninsured losses were basically what the property owners were left with. Who else could possibly pay for this besides the insurers? Well, the banks have lots of money. They're a pretty big target, and I'll say something about that in a moment. Another idea, potentially, scientists. Could scientists pay for this? Are they somehow responsible for not giving us enough timely information? Don't worry, Trevor. Haven't got anything planned on that front at the moment. But also, what about large fossil fuel companies? And what about professionals, the people that are providing advice about how many of these things operate, these large pieces of infrastructure that are failing? There's a lot to consider. And one of these images is a whole book called Climate Change Liability, and it's not the only one, speculating about, well, analyzing different approaches that could possibly be taken to recover some of these climate change damages. So really what we're seeing now in the common law is this sort of probing of all the possibilities. What could be done about this? How could the law find its way to allocate some of these damages that we're seeing? So these are just some high-profile examples, but there are quite a few I could have chosen. It's just a small selection. One of the earliest ones was a lawsuit brought against the U.S. Army Corps of Engineers after Hurricane Katrina hit New Orleans and wreaked its devastation. That was a $77 billion lawsuit. Ultimately, it wasn't successful as a lawsuit because the court said that the Corps, the U.S. Army Corps of Engineers, was immune because it was a public agency. So they said, oh, you can't sue them. They're essentially a piece of the government. So that was lucky, really lucky for the Army Corps of Engineers, because since then, a lot of research has emerged that has suggested that really they were quite responsible for that. They really shirked their duties. So, you know, close call, but still it didn't quite work. Another case that was relatively early was an Alaskan village took some of the fossil fuel companies to court because the land on which their village sits is disappearing as a result of global warming and the impacts it's having on the north. And they have to relocate and find somewhere else to live. That also was knocked out kind of on a technicality because they brought it in federal court and the court said, oh, well, you know, the US federal government at that time was taking some action to reduce greenhouse gas emissions. So essentially they had covered this with a legislative and executive response, so they weren't going to recognize this type of a lawsuit because they felt the federal government had occupied that area. More recently now in the States, in California, San Francisco and another city have brought actually quite a similar action against a number of the large fossil fuel companies. And they're saying, you are partly responsible. You've made a contribution through producing fossil fuels and drawing profits from them to the state we find ourselves in now, which is that we have to adapt to sea level rise. And it's going to be quite expensive because we're a coastal city and we weren't prepared for this. So that's another case that is very similar to the Kivalina case, but this time it was brought in state court. So it will not face that same issue of being knocked out because of the federal jurisdiction. And also, we have more information now. There's been research done in the UK led by Richard Heady that has gone a long ways towards attributing the amount of greenhouse gas emissions that are in the atmosphere to the activities of particular fossil fuel companies. So now we have a causal link that was a bit weak before. We have that piece. Another thing, there's been work done by a number of organizations and also by state investigators in, I believe it's New York, into the activities of some of the fossil fuel producing companies over the years such as ExxonMobil. And that work has shown that they've known for quite some time about the harmful impacts of the products that they produce, these fossil fuels. They know it's having an impact on climate change. And yet they have, at the same time, lobbied against efforts to rein in fossil fuel emissions. So there is this kind of underhanded nature of the way that those companies have been addressing these issues that also probably will not act in their favor when they're at a court. And then I just threw this one in at the end because I hadn't really seen anything about banks. And as you know, most of the big banks are heavily invested in fossil fuel production. And they really have not been part of this conversation. But I noted that a couple of shareholders of the Commonwealth Bank of Australia, which is one of the big banks in Australia, recently brought a claim, and it was essentially it was an injunction, so it wasn't a claim for damages, but they were forcing them to disclose the climate risk of their investments. So starting to push in that direction as well.
Has anybody been successful in drawing the parallels to the tobacco companies? It sounds like it's a lot of the same situation as big tobacco 20, 30, 40 years ago.
Yeah, absolutely. That's precisely the comparison that's being made. And certainly with the cases in California, those analogies are being drawn. And also here in BC, my colleague Andrew Gage works on a program at West Coast Environmental Law called Climate Law in Our Hands. And at this stage, we don't have any lawsuits in BC, but we do have local governments exploring this relationship with the fossil fuel companies, and several of them, including the city of Victoria, have actually sent what they're calling a climate accountability letter to a number of the major fossil fuel producing companies, saying, look, we're facing these impacts. We'd like to know how you're going to contribute your fair share of the costs of dealing with those impacts. So when we're talking about these really large cases, there's some important things to consider by way of background. I mean, we're going to dive into professional risk in a moment, but just to understand from a legal process perspective what it means to be involved in a large-scale lawsuit. First of all, in the case of multi-party litigation, you start off maybe you have the plaintiff, the claimant, and they sue some defendants, and there's a lot at stake. So those defendants turn around and say, right, who else can I get on the hook for this? And they add some other folks who we call third parties. And then you have the lawsuit starts to sprawl, essentially. So you get more and more parties involved. And the more parties you have, the more expensive it is, right? And once you're in one of these lawsuits, with multiple parties, it can be hard to get out because it's hard to get everyone to agree to let you off the hook because no one really wants to make that decision until everything's finally settled. So it usually can go to the bitter end unless you can make an absolutely clear case that you have nothing to do with the damages that are involved. And this image here is a leaky condo. And back in the 90s, leaky condo litigation was just going crazy in BC. And this was a classic case of multi-party litigation where professionals were involved because the people who lived in these condos were left with these problems. They turned around and sued the developers, but often the developers were in shell companies, so they just weren't there anymore. They had moved on. Then they went to the builders. Then they went to the professionals, the architects and the other construction professionals that had been involved. And these lawsuits carried on for a long time, and people built whole practices around them. So this litigation can be quite messy and long-term. The other tool that we have in the Canadian legal process that's important to keep in mind are class action lawsuits. So most local governments face constant claims of various sorts from property owners and others within their local government jurisdiction. And sometimes it's the kind of thing that's an angry phone call that's resolved, and sometimes they actually end up in court. But typically, historically, these would be more like kind of one-off small things, and they would just have some budget, and they'd have a city solicitor, and they would deal with these things. But now, with the possibility of class action lawsuits, you can actually aggregate those claims really effectively from the point of view of bringing the claim. And so now, instead of having a number of small claims, you can have really gigantic claims. And we've seen some, particularly in Ontario around flooding, where the claims are looking at hundreds of millions of dollars of damage for essentially a single flooding event and alleging that there was some negligence in terms of maintenance of infrastructure, for example. So again, this is something to keep in mind when we start talking about these large-scale claims that it can be expensive and really quite serious. So let's drill down then into some of the specifics of professional liability. How do professionals get drawn into these cases? So typically, professionals are sued because they're said to have been negligent. And negligence is a particular tort or a particular type of claim in the common law. And it has evolved over time through the courts to have these specific characteristics and requirements in order to make that claim. So I won't get into a ton of details, but just to give you the high points. So the first is that you're saying if you're going to make a successful claim that the defendant owes the claimant a duty of care because of the nature of their relationship. There was something close about it that made the claimant think that they should be relying on the defendant. So this is usually pretty straightforward in the case of professionals, because typically a professional is giving specialized advice to people because those people have requested it from the professional. So that part's usually pretty straightforward. The standard of care, this is a little more interesting in terms of climate change. What is reasonable in the circumstances is the broad question that the court will ask. Now, so it's a standard, it's meant to be an objective standard of what would a reasonable person have done in those circumstances. But in the case of professionals, it's not just what any reasonable person would have done, it's what would a reasonable, qualified, thoughtful, prudent professional have done. So professionals are expected to be more knowledgeable than lay people by the courts, which makes sense because they have professional qualifications. And so you're being compared as a professional to your peers. And then finally, a piece that's important to consider here in terms of climate change is the causation. So was the harm that resulted foreseeable to the defendant when they were giving the advice? Now say, I don't know, let's put it really far back. Let's say 50 years ago, you couldn't have expected a professional to be saying, well, we should take climate change into account. Maybe 20 years ago even, it was a little iffy. Scientific community probably was pretty well aware of what was going on. That letter from those scientists was 25 years ago. But now, where we are in the present day, the knowledge about climate change might not have generally permeated through the population, despite the best efforts of people at communicating it. But still, I would say we were at the stage where we have enough information about climate change impacts that we can say that this is foreseeable. There are other issues around exactly what is foreseeable, but we know that climate change is happening. And Trevor, of course, takes care of the Plan to Adapt site, which gives very specific information about climate change impacts in BC for communities around the province. So we have lots of information about climate change. There isn't really any doubt that it's happening. So I wanted to highlight this because I think there's also a sense when we start talking about, well, what would be reasonable in terms of professionals and professionals as compared to their peers. Don't feel that that means that if everybody is relatively complacent, the courts are going to accept that, because they won't. And this is a quote from a Supreme Court of Canada case and Madame Justice Laura Dubé. And what she said was, the fact that a professional has followed the practice of his or her peers may be strong evidence of reasonable and diligent conduct, but it is not determinative. If the practice is not in accordance with the general standards of liability, that is, that one must act in a reasonable manner, then the professional who adheres to such a practice can be found liable depending on the facts of each case. So even if a majority of professionals in a particular field of practice felt that climate change wasn't worth considering at this point, if you could put forward information that showed that really it was highly relevant for decisions that they were making, a court would likely find it reasonable that the professional should have taken climate change into consideration. So I wanted to note that professional associations in BC really have shown some strong leadership on climate change, and all of their members should be taking notice of what the associations have been providing. APEG, or no longer APEG BC, EGBC, Engineers and Geoscientists BC, back in 2014, issued a position statement on climate change that deals mostly with climate change adaptation, noting that their members are expected to keep themselves informed about the changing climate and consider how climate change impacts affect their professional activities. And then there was also the same year, I believe, a joint statement from the Planners Institute of BC, the Association of BC Forest Professionals, the College of Applied Biology, the Association of Professional Biologists, and the BC Society of Landscape Architects that acknowledged as well that climate change is a big factor that should be taken into account by all of their members in the work that they do. And they said at the end, we expect our members to build upon their current science-based, knowledge-driven approaches to better incorporate the best available climate science into professional decisions. So it's really an obligation and a duty of continuing professional education, because as we know, the climate science is evolving. So what I've talked about now really is, an overview of claims that would be brought in negligence. But there's another type of tort claim, another type of common law claim that I think is really relevant that I'd like to draw your attention to, and that's nuisance claims. And typically many of the cases that we've had in BC over the years dealing with failures around drainage in a local government context have been nuisance claims. And those claims have typically been quite successful in terms of bringing some damages to the claimants that have suffered the impacts. And so just to characterize briefly what goes into a nuisance claim, because it's a little bit different than a negligence claim. It's really based on Old English property law, essentially. But you have two types of nuisance. You have private and public nuisance. And the tort of nuisance is unreasonably interfering with the enjoyment or use of someone else's property. And in the case of private, it's private property. In the case of public property, it's, say, like a road or something that has common value. So in the cases, flooding usually made the grade as unreasonable interference. Flooding is not usually acceptable. Local governments themselves do have some statutory immunity because the lawmakers have acknowledged that it's impossible to run a local government and not have some things break down once in a while, and so they didn't want local governments just to be continually facing these types of lawsuits. But they conditioned that immunity here in BC in a particular way, and they said only if it's a result of a breakdown or a malfunction of, for example, drainage infrastructure. So one of the leading cases here that's cited in many cases was the Meadow Mist Farms case. So that was out in Surrey, and Surrey was growing. It has been growing for many years, and there was a lot of increased upland development, and the amount of impervious surface increased, and so less water was going into the ground, more water was flowing downstream, and there was a ditch in a farm that previously had been able to accommodate the water that was coming downstream, but with the increased development, it wasn't able to, and it was flooding this farm. And so the farmer took the city to court, and the court said, yeah, the city is responsible for this because this isn't a malfunction. This is just the drainage infrastructure not keeping up with the increased water that's coming down. And I think this is highly relevant to consider in a climate change context because we're definitely facing periods of more intense rainfall in most areas of the province. So nuisance as well as negligence should be on your radar, particularly if you're a professional that's giving advice to infrastructure operators like local governments and other utility operators. So just to sum up then, It would say that professionals, as professionals, and of course I'm a professional as well, and need to take into account climate change in my practice. We have liability issues related to climate change. We can't ignore the science of climate change. Even I'm an environmental lawyer, so perhaps I'm more aware of climate change, but even if your practice isn't directly about climate change, you still have obligations related to understanding the impacts of climate change on your practice and finding out what they might be. The main thing to remember really is that the past no longer predicts the future. So in most of our professions, we're used to building on what has come before us and drawing lessons from the past. And of course, that still applies, but not in the same way as it did previously, because we really have a future that is changing more rapidly than the past ever did. So professionals, as I just mentioned, you can also be advising owners of infrastructure and others, and so you have to keep in mind this need to keep climate change in the forefront of decision making. I've heard people say that, well, we talked to the clients and we told them, they should look into these climate change risks, but the clients said, well, we only have a budget that does X, Y, and doesn't do X, Y, and Z, and Z is climate change. So we're not going to go there, but thanks for the information. Well, I would suggest to you, no matter what profession you're in, that you need to be very careful about those situations. I mean, if I'm a lawyer and someone comes to me and says, I have this problem and it's a contract problem and I want it fixed. And if I look at it and I see some issue that's not a contractual issue, I still have to let them know about that. I'm not off the hook. I could be negligent if I didn't tell them, everything that was wrong with their situation and every claim that they had. So it's the same thing with other professions in climate change. If the client doesn't want that advice, you still need to get it on the record that you offered that advice to them and they didn't take it. In a way, that can also be a way to help drive change too, because for example, if you're dealing with a local government and you provide this report and then council gets a look at it and they say, oh, they wouldn't fully, they signed off on this only conditionally because we didn't consider climate change, then maybe it's a driver for them to think about doing things a bit differently and actually bringing climate change into the conversation. So, there are professional risks related to legal aspects, but then there are also professional risks and responsibilities. So we have ethical responsibilities as professionals. We're thinking about keeping our planet Earth safe and habitable for the children, the future engineers here that are coming down the pipeline, for example. And also generally the credibility of the profession. This is, as climate change becomes more and more understood, we as professionals are going to sometimes be in the spotlight in terms of talking to people about what we should be doing. So we needed to have that credibility. And one of the interesting things that I was involved in last year was working on a public engagement process with the city of Surrey and in a particular neighborhood called Crescent Beach, which is right on the waterfront, and it's really going to be quite seriously impacted by sea level rise. And it was an education and engagement and mobilization effort, I guess, that spanned a couple of months of meetings and workshops. And one of the really interesting things was that by the end, when the residents who were participating really got a grip on what was going to happen in their community in terms of sea level rise, they started saying, well, what are we doing? Where's the component of this program that involves reducing our greenhouse gas emissions? We can see how terrible the impacts are going to be now. We really feel like we should be doing something about it. So I think it's important to remember that these efforts of education and bringing clarity to the impacts around climate change also have a really important role to play in mobilizing us to be more proactive in reducing our greenhouse gas emissions and having people understand why it's so important. And professionals have also made this connection, and again, this is a position statement from Engineers and Geoscientist BC from 2016, So kind of the companion piece to their 2014 piece on adaptation, this is about greenhouse gas reduction. And I highlighted the second part of that opening statement where it says their members have the potential to influence greenhouse gas emissions through their professional activities and are expected to consider the impact of their work on the climate. So even in terms of designing, for example, new pieces of infrastructure, large buildings, bridges, is there a way to also make those new structures, those new buildings, less greenhouse gas intensive? That's something else that is a big piece of this. There isn't necessarily legal liability associated with that at this point, but I think it's part of the aspects of professional reliability that we've discussed. So, on this theme, we do need to reduce our greenhouse gas emissions, but we still need to adapt because we are committed to a certain level of climate change. And we're still left with quite a bit of uncertainty about how to manage it. But what we really want to avoid, given this uncertainty that we're facing, we really want to avoid approaches that have built-in potential for catastrophic failure in light of this uncertainty. So this is a picture, I apologize, it's a bit blurry in on the screen here, but I think you can make it out that it's a berm. It's in Delta. This is 2006, and the berm has failed. So the water's come through, and you can just see on the right-hand side there the school bus sort of floating out of view, and I'm hoping it was empty. But this is an illustration of a solution that, when it's working, it works 100%. It works great. Keeps the water out entirely. You can live your life behind that berm as if you were not next to the water at all. But once it fails, it's just over. It's really a significant problem. There's no in between. It's yes, no. So this is the kind of solution that we want to start moving on from. It's not that we're not going to have any berms, we're not going to have any seawalls or dikes, but we need to think about how do we work with nature in such a way that we're not just trying to constantly battle it back, because we're not going to win. We're going to have some really big losses. And we can't totally fortify ourselves. We can't all live in bomb shelters underground, right? We've got to think about how we're going to exist in a world with these climate challenges. And the other thing is, we probably can't afford to entirely fortify our communities, even if we made that choice. In the Lower Mainland, it was estimated that it would cost about $9.5 billion to upgrade the hundreds of kilometers of dikes that exist in order to meet sea level rise guidelines. So that's the meter by 2100. Since then, since that study was prepared, another study was prepared looking at the state of the dikes right now. And they were found to be so unsatisfactory that I think that you'd have to go back and recalculate that 9.5 billion, because it's not like we can just upgrade a beautiful system and make it a little bit higher. Like in many cases, we can't even upgrade those existing dikes just because of seismic issues and other problems with them. So I'm not sure that makes sense to pursue that, given these large numbers and given the likelihood that we're not really going to pull it off anyway. So the idea really is to start thinking about some other ways that we could approach this. How could we be more resilient to a changing climate? So something that seems to hold a lot of promise is working with nature instead of fighting it all the time. And there are lots of names for this, but we'll call them nature-based approaches here. So this is a photo of Lynn Creek, quite a ways upstream on the North Shore, over in Metro Vancouver area. And this is taken a couple weeks ago in the fall, so the flow in the creek is pretty low at this point. But you can see the broad area where the creek is at times. And in the spring, when the snow is melting and the water is really coming down, the creek is, of course, across. And anybody who spent any time in creeks knows this phenomenon. But what we're really seeing here is how resilient nature is. Nature doesn't have a catastrophe itself when it has a lot more water coming down. It's set up so that it accommodates that. It has a kind of a transition zone. So it doesn't take out all the trees. I mean, if there was some, really extreme event, maybe there could be some things happening higher up on the bank. But generally speaking, it does pretty well. It manages this flow. So I put to you that we need to think more in this manner of how do we accommodate some of these natural phenomena, these natural hazards a little bit better. And we have been doing this work in BC for a number of years, looking at green infrastructure for rainwater and stormwater management in local communities. And there was an interesting study done actually right around here on the Bowker Creek. And Chris Jennings, who was doing some work, I believe, at the University of Victoria at the time, modeled what would happen if you implemented 3 different green infrastructure measures throughout Bowker Creek. And they were rain gardens and increased topsoil, and I can't remember the third, but it was a relatively easy measure. He found that you could implement those at such a scale that you could deal with a 22% increase in precipitation that was predicted for this region over the next decade. So you wouldn't even have to upgrade the existing infrastructure. You could use these measures instead. And when a single rain garden fails, it's not a disaster, right? It usually doesn't flood even a single person's basement. It just gets some water on the street. So if all these small measures, if some of them fail, it's okay, we can accommodate that. If some of them get topped up, if you got, for example, 23% increase in precipitation, again, it wouldn't be a disaster. So what this really is doing, as a colleague, Tamsin Lyle, likes to say, is taking the edge off the risk. So there's still risk. You still have the hazard. You haven't completely mitigated it. But it's not a disaster anymore. It's not as sharp. So this is an area that West Coast Environmental Law has been working in pretty actively, and in particular looking at what are some nature-based responses that we can explore on our coastlines, given this challenge that we face with trying to, the impossibilities around completely armoring our shorelines, and also the undesirability of it, because we will lose all the coast that we love if we put up walls, because as the water rises, the water eventually is going to go right up to the walls. And all that foreshore, all those beaches that you want to walk on, where the forage fish live, all that habitat where the birds are, that'll just disappear if we put up walls everywhere. So we need to think about what we can do differently. And we do have this example of rainwater management, and what we've learned from that is that it takes a collaborative approach, because using rainwater management and deploying these measures across a landscape, it's essentially a land use exercise as well as an engineering exercise. So you need the planners and the engineers to work together. And in some of the work we've done, that's been exactly what we've done, is we had workshops and put people together to try and, across disciplines, understand how to work together. Now in a coastal context, we're facing a similar thing, and what we're really finding is it's the engineers and the biologists. So the biologists know about the coastal ecosystems. They know how valuable they are. They know how they're affected by coastal processes, what's going on out there. And the engineers have ideas about how to model things. So what could we do in that foreshore area, for example, that would break down the wave energy so we wouldn't have to raise the dikes so high? They have that information. So you have to put that together. That's not always easy, because these two disciplines don't necessarily talk to each other, but those are the conversations, some of the conversations that we have to have going forward. And ultimately, if we want to implement those types of responses, we're going to have to develop some technical guidance that can inform regulations, and also practice standards so that people working in the professions will know what to do. But there are examples out there of this approach of, for example, combining flood management and ecosystem protection and restoration. And one of the really prominent ones is, I guess, a result of Hurricane Katrina. It's the Louisiana Coastal Protection and Restoration Authority. And they're doing some really interesting work. They just issued their second 5-year strategic plan, and they're really combining these two things together. maintaining the ecosystems, but also getting the benefits of flood management. And then also something we're really finding in this area is that the legal jurisdiction is very complicated because we haven't managed our coastlines in this way, in this integrated way in Canadian law anyway. We've managed them by what we want to do, so the different uses that we want to make of the coastline. And so we have a bunch of different places, different agencies that regulate different bits of the coast, but they don't necessarily talk to each other. So some of the work that we're doing is just convening and trying to develop some common understanding about where we could go with this, how we could explore these ideas collaboratively. So in closing, I guess I'd like to say it's a beautiful place we live in. We're so lucky to be here. We have these challenges, but we have immense opportunities still to do things in a good way. And one of the things that is really positive is that we know that First Nations have lived here sustainably for millennia, are still living here. And they have deep knowledge about resilience in working with nature that they refined over hundreds of years. They faced lots of challenges, maybe not climate change, but all kinds of really serious challenges. And they adapted and were resilient. And we can definitely learn from that. So given that we're in an era of not only climate change, but also reconciliation, we have this opportunity now to work together and find resilient paths forward together. And I would say as professionals, we really need to open our minds and our hearts to these possibilities. And thank you.
Well, that was terrific. Thank you very much. Very clear, too. Do we have some questions? Yes, here and, yep, please.
You talked about how standard practice might not get you off the hook from a liability perspective. Do you know if anybody has tested anywhere in the courts whether professionals that are following voluntary kind of best practice or leading edge practice guidelines, I'm thinking here, for example, shorelines, there's the Green Shores system, invented right here in BC, or in buildings, leadership and energy and environmental design lead. I'm sure there's others. So, if you, as a professional, that doesn't clearly get you off the hook for doing the right thing on an individual project. But if you said, look, I'm following the best practice, not just standard practice, and it's leading, has that been tested at all? Do you know?
I'm not aware of any cases, for example, with Green Shores, but it's a really interesting question, and I was thinking about this as well when I was doing some research a while ago, just looking for some, I guess, trying to find if there were cases to find some kind of grainy bits that we might think about in terms of providing advice about what those standards could look like. And it occurred to me that maybe it's because in those cases, for the most part, we haven't really seen any really epic failures. On the one hand, we don't have a lot of cases to look at, so we don't have huge widespread uptake yet of those approaches. But I was wondering also if there's something to do with, it's not the same as where something just, falls down. Like you'd have to have, it would take some time, and you just might not have the kind of impact that you could draw on. But in terms of what your question is probably more directed to, it is, can you get some comfort from that? I think so. I think a court, I don't know if we have any case law, but I think a court would find that this effort to embrace best practice would be a reasonable step. I mean, it just depends in terms of whether the best practice that you're following has everything that's required in it for your profession. Does it cover you in that regard, right? And that's a matter of your professional judgment.
Question back here? No?
Hi, just following up on that question because the gentleman mentioned that. Sure. My name's Leslie Welsh of Environment and Energy Consultancy. following up on the last question, he referred to standards. And of course, standards are widely used in our society. We have various standards setting organizations, such as the Underwriters Laboratory of Canada and the Canadian Standards Association. We have many other types of standards, building codes, a number of international standard setting organizations. And these organizations attempt to create standards for engineering design and engineering practice that typically are performance-based and typically are risk-based, so that you create a performance standard that will account for the risks from the environment, including climate change, perhaps. But in reality, in my knowledge of the standards, virtually none of them include climate change risks within their form. And I'm wondering what responsibility and what potential legal risk might exist for standards setting organizations themselves in failing to address climate change impacts.
That's a good idea. Maybe I can add them to the list of possible targets. Well, but let's just back this up. So the standard setting organizations that you're referring to would be something like the ISO standard, for example. Yeah. Well, I guess you could approach them. I mean, I think as a professional, we've talked a lot about engineers, but engineers, to be honest, figure fairly prominently in climate change adaptation because of the infrastructure risk. So let's stick with engineers. I mean, ultimately, if you're an engineer, you're judged by your professional association and by the professional standards of that association. So can you completely rely on this external standard if that association is not, is it endorsed by the association?
Universally accepted.
Yeah. So, I mean, in that way, it kind of becomes a standard of practice, right? Like just a sort of, like a small s standard of practice.
Minimum standard.
Yeah, just part of that array of standards that you're taking into account when you're working. And so, I mean, going back to what the courts have said about is that standard enough? If the court doesn't find it reasonable, so would it be enough if it doesn't consider climate change? Probably not. So in terms of protecting you, relying on it, so could you turn around and sue the standard maker? I'm not sure, because I think as a professional, you're expected to exercise your own professional judgment and bring in the climate change lens if it's needed.
Jack Meredith, engineering practice here in Victoria. Excuse me. Can you comment upon the legal aspect? I think you're talking Canadian law, and you made some references to things happening in the US. I can see countries like Bangladesh or low-lying countries seeing these issues sooner. Can you speak to whether you see there's liability that a professional might have, or a fossil fuel company who could be exposed to some kind of suit, international suit from a country or for a disaster in low-lying countries?
Yeah, absolutely. There's quite a bit of work. I'm probably not the best person to comment on that in any detail. My colleague Andrew Gage is actively working on climate change compensation litigation, and he does have some papers that are published on our website if you're interested in reading anything more detailed. But I can confirm that yes, these issues are being explored, and certainly from a private law perspective. So private law as opposed to the law of treaties, which is considered public law, it's quite a bit more supple in a sense of making these types of claims. So you could picture one of these countries, say a low-lying island country, might be interested in bringing a suit against fossil fuel producing companies, just like San Francisco has done. And then through the magic of private law, they could potentially enforce a judgment in another country where that fossil fuel company had assets. And I mean, there are definitely some hurdles to get through in order to have that happen. But that's definitely potentially on the horizon, that we're going to start seeing those types of claims as well. It's all in the mix. Yeah. So what they might do is, for example, let's say this island country says, we've faced all these impacts. We're going to pass a law that creates, quite strict liability for the fossil fuel producing companies, and we're going to use this analysis about how much, the amount of greenhouse gas emissions that are in the atmosphere as the causation, and we're going to make hold these fossil fuel producing companies responsible, and we're going to have a law that smooths out some of the issues that might otherwise be there if we just try to bring it strictly as a common law claim. And so they bring that claim. Their courts find that the companies that they've sued are responsible. So now they have a judgment. Now they go to another country where they have an agreement with that company about the mutual enforcement of judgments in private law, because we have these types of agreements with other countries, and they enforce that judgment in the country. So at this point now, if everything lines up, they're in court and they're not actually even arguing the merits of their case. They're just saying, this company owes us this amount of money based on this judgment, and we need to enforce it. So as I said, there's some hurdles and some twists and turns involved, but that's essentially the theory of it.
We have a question from our AV team here. Let me give you the microphone here.
Thank you. My name is Navneet, and I work for AV Services at UA. As a lawyer, do you think our courts are well equipped to handle litigations that you do, or do we have a specialist court? And how much time does it is involved in the litigation? Like, is there a direct appeal to the Supreme Court, or do we have a green tribunal to adjudicate cases like this?
I'm sorry, could you repeat the first part of your question? Maybe if you're not standing behind.
So how much time does it take for the class action suits to kind of finish, and like by the time the courts they give a verdict on it? And is there an appeal? Is there a direct appeal to the Supreme Court, or is it just the regular process of our courts that takes place? Because I'm concerned how much time is actually spent on the litigation.
Sure.
Is there a thought for a green tribunal, or a court that just deals with issues which are similar to environment and stuff?
Yes.
That's what the question is.
Well, lots of interesting questions there. So the first one was the class action lawsuit. How long does it take? It depends, right? Sometimes they're settled quite quickly, just because the parties that are being sued just want to get out of it, and they make a calculation about how much it's going to cost them to go through the process. So that could happen quickly, or it could drag on for years. In BC, we have made efforts over the past decades, I would say, to make the legal process more efficient, but still things can get bogged down, particularly in civil lawsuits. So it could take some time. And yes, the decisions can be appealed. It's a regular case in pretty much every other way. It's just kind of the constitution of that class of plaintiffs is the special feature. And then the last question was, and so yeah, that's a really interesting question. We don't in Canada, but they do have kind of a green, well, I wouldn't say it's a green court, but kind of a court of the environment in Australia, and I believe it's called the Lands and Environment Court, or something like that, but it deals specifically with land and environment issues. So something to think about, to have that. Yes.
That kind of specializes on the issue of tax.
Yes.
So it would be worthwhile.
Yes, we could have one. We could create one.
Okay, well, I think we should close here and thank Deborah once again for a great presentation. And I think if anybody has any additional questions that she might be willing to have you come up and ask her after the fact. Yeah?
Sure.
Okay, great.
Yeah.
Thank you very much. And again, if any of you are interested in signing up to hear more about our activities, please come up and put your name and email address down, and we'll get you on the list.